To the All right, so we're going to get started with the second in our February Focus on Forms. Today we are doing the exclusive buyer contract. Last week we did the exclusive listing contract. So we're going to do a deep dive into all the different paragraphs found in the buyer contract that we've been using that's provided to us from the Michigan Realtors. So let me pull up the document. All right, so this is the contract we use. It's Form JJ because we are a designated agency, not a traditional agency. And so, yeah, it's provided to us from the Michigan Realtors. They're the ones who drafted it. We've been using this for um, since the settlement in August of 24, I believe. But yeah, so it's always good to every so often do a refresher. If you think you're very comfortable with this document, well, maybe hopefully at some point during today's class you learn something that maybe you had forgotten or just were never aware of. But yeah, so to start with the contract date, this is the period in which this contract is going to apply. Now, with the changes to our practices, where you need to have this contract in place and signed before you ever open a door, getting this signed by those random leads who contact you, uh, there's a lot of times where there may be friction involved that they don't want to sign a long 6-month contract. It is totally fine for this to be a 2-day contract. You could have it be from February 9th through February 11th, and we'll get into why that's okay. It can still protect you and all of that. But yeah, so just be aware you have to have contract dates, both the start date and the end date, but the duration, the length of it can be up to you based on your conversations with the client. The brokerage firm, clearly Remax Platinum. And then gonna list off any and all designated agents that are part of your team. If you're an individual, it's just your name. If you're part of a team, then we need to have all of the agents that are part of your team where if they were to get work with this client as well, that the agency is already established as a result of this contract. Um, Most importantly, this deals with dual agency, where if you have a listing that your team is representing, and then you have a buyer's agent also on the team representing the buyer, well, we are a designated agency where if you're both Remax Platinum agents, but not on the same team, it's totally fine. You can maintain your separate representation, one for the seller, one for the buyer. But if you're on the same team, then you are required to do dual agency. If one of you, even though you may never have talked to the other client, the fact that you belong to the same team, then you have a dual agency situation. And so all agents that are needed to be listed off here as members of the contract because um, just to be compliant with agency. You'll have your email address, phone number. Supervisory broker is going to be myself or Nicole out of Brighton or Rob down in Ann Arbor, or you can put Joe DeKrug. The buyers, here you want to have any and all buyers that are going to be on the eventual purchase agreement, need to have them listed off here. And in theory, it needs to be anybody that you're showing the house to as a potential buyer, because um, if let's say the buyer is out of state, but they have their mother meeting you at the house to take a look at it, then you need to have their mother's name here. They need to be part of the contract because in order for you to take them through the home, there needs to be an established agency relationship. That's part of the settlement, which is a strange thing, but it is what's being required of us. Having their home address, email address, phone number, not required for the contract, but a good opportunity to get those little pieces of information and add it here so that way you have it for your database. All right, getting into the actual meat of the contract. The scope of the agency defines what it applies to as far as what real estate. So broker and buyer agree that the broker shall act as the buyer's exclusive agent in connection with the buyer's possible purchase of the following desired property. So it can be any real property in Michigan. So that would be a statewide, any and all real estate transactions. You then are establishing that you are their exclusive agent when it comes to the purchase, possible purchase. You could narrow it down to only specific properties. Now it says to insert addresses, but it doesn't have to just be specific addresses. You could narrow it down to all properties in Livingston County, Michigan. You could have it be all residential properties, or any narrowing from the first option of any real property. You can narrow it down to however you and the client decide. So it may be if you're meeting that random lead at a home and you're having them sign this before you open the door for them, yeah, you could have it be that it's okay just for a couple days, or you could have it be that it's a longer term, but down here you list literally just the address that you're showing them, and then if they want to see another property, you can then write in another address and have them initial it. You initial it as well to continue to expand upon it. That's not necessarily a best practice, though. Obviously, if that first showing turns into additional showings, you eventually want to get a new contract written or indicate that it's going to be just the top option for any property. All right, moving on to designated agency. The broker and buyer hereby designate the agents named above as the buyer's designated agent. So everyone listed on this line. Buyer shall have an agency relationship with only the broker and designated agent and supervisory broker named above. So Joe DeCruz is the broker, the supervisory broker, like myself, and any designated agents here. But because we're a designated agency office, it does not mean that this contract creates a agency relationship with other RE/MAX Platinum agents. So if there's an Ann Arbor agent that they end up interacting with, well, that Ann Arbor agent, despite being part of our brokerage, they are not covered by this contract because they aren't either on this line as a designated agent, they aren't the supervisory broker or the broker. Buyer acknowledges that neither the designated agent nor supervisory broker named herein are acting as attorneys, tax advisors, surveyors, appraisers, all the different other professions. So in the listing contract, this was much later on in the contract. I think it was maybe like item number 17, which basically just lays out that we stay in our lane as real estate professionals. But and we are explicitly stating that we are not experts in surveying or being a tax advisor. So they should contact professionals in those areas if they have interest in relying on professional advice for environmental experts and such. So what the common theme of this contract is about protecting our brokerage. The common theme in the listing contract, that was one where you're basically creating an initial offer to the public that somebody could come along and say, I accept that offer. And now all of a sudden you have an obligation, a binding contract to a transaction. It's not about creating a binding contract to a transaction. This is about, the details here are about protecting the buyer brokerage, us, um, in case things go awry, I guess. So neither the designated agent, ourselves, nor the supervisory broker is in a position to advise buyer as to the location of any property within a floodplain or as to floodplain insurance requirement. Buyer is encouraged to visit the website floodsmart.gov and or consult with appropriate professionals. I'm pretty sure that the reason Michigan Realtors put this in here is due to a legal requirement potentially. And again, though, it is just to protect us, because yeah, if they we should be encouraging our clients to be familiar with the floodplains and what flood insurance means if they were to purchase a home that has a flood insurance requirement on it. But yeah, so this protects us if they later come along and say, you didn't tell me the home is in a floodplain. Well, we are not in a position to determine that for them. They should do their own due diligence. Number 3, exclusive agent. Buyer agrees that during the term of this agreement, any and all inquiries and or negotiations on behalf of buyer relating to the acquisition of property listed off here shall be through the designated agent. So during the length of this contract, they should not, when it comes to properties as identified here, they should not be going out there talking directly to sellers and trying to make offers. They are agreeing that they are going to rely on us to be their medium to communicate with others when trying to purchase property. All right, compensation of the broker. This gets to be an area where the settlement made some changes, but it, I think, is pretty straightforward. So the brokerage firm's fee for services rendered is not set by law and is fully negotiable. You are allowed to negotiate. But that does not mean you have to accept any negotiation that the client is requesting. Just because a client may want you to work for 1%, you do not have to. You can say that, yes, you're allowed to negotiate, but you personally don't work for 1%. That's a fine statement to make. Just as, a listing the purchase price may be negotiable. It doesn't mean they are required to accept an offer, at 50% of the list price. You are not required. It's just there's nothing that is forcing you as an agent to take, at least 3% or whatever it may be. So, broker may not receive compensation for brokerage services provided to buyer from any source that exceeds the amount agreed upon below. So what that means is, this is going to set a cap on what we can receive in compensation for any transactions that they are a party to. In consideration for the services to be performed under the agreement, buyer agrees to pay broker as follows. So these first two, you have a retainer fee, where if you wanted to accept a certain payment up front that is non-refundable, you could accept that from the client, due and payable upon the execution of this agreement. So you could say, hey, in order for you to be showing them homes, you require a $500 upfront retainer fee. Treat yourself like a professional, like an attorney may. And if you're able to find clients that agree to that, that's totally fine. It does say then that the retainer fee shall be applied against any commission owed to broker. So applied against this. If you do a $500 retainer fee and then you have additional stuff down here, then that $500 gets applied to this obligation. And that's where, so these check boxes are not an either or. You could have multiple checked off. Just now, most agents don't check this box. They don't check this box. They don't check this box. This is all they check, but we'll get to that. Hourly fee. This is an option where the buyer will pay broker an hourly fee of, what is your services require? $200 an hour for services performed under this agreement due and payable upon receipt of invoices from broker. The hourly fee shall be applied against any commission owed to broker. So you could charge $200 an hour, and then have a commission in here as well, but you're going to deduct from that commission anything that they're paying towards the hourly. All right, flat fee. This one does not get applied against the commission, is something I realized, which I thought was interesting. In the event buyer contracts to purchase the desired property, buyer will pay broker a flat fee equal to, you could have it be $10,000, whatever it may be. The flat fee is due and payable upon closing, provided, however, that if the transaction does not close because of any default on the part of the buyer, the flat fee shall become immediately due and payable. So if the buyer walks and is in default on a purchase agreement where they're sacrificing the earnest money deposit, they also at that moment owe the flat fee commission. The flat fee obligation shall apply to any purchase agreements executed during the term of this agreement or during any extension of this agreement. The flat fee obligation will also apply to purchase agreements executed within, so this is a protection period, you can do 6 months, 3 months, after the expiration or other termination of this agreement, if the property acquired was presented to buyer during the term of this agreement. We're going to go into the protection period down here and explain what that means. But yeah, so getting to the norm, like the most common compensation paragraph is the commission. So in the event buyer contracts to purchase the desired property, again, any property up here, buyer will pay broker a fee equal to, here's where we have our $4.95. So that's just a flat fee. That's the broker compliance fee, and a commission equal to 3% of the purchase price. The commission is due and payable upon closing, provided, however, that if the transaction does not close because of any default on the part of the buyer, the commission shall become immediately due and payable. So just like up here, if the buyer defaults, they still owe you a commission. Now, is it good practice to sue clients for your commission if they don't actually end up purchasing the house? Well, that's up to you to decide. I mean, I think most of the time agents don't pursue litigation, but I mean, yeah, you definitely have that possibility, and you can always also have us as the brokerage be the bad guy, quote unquote, where if you have a buyer that's wavering on whether or not they want to proceed with a transaction, you can tell them like, hey, not only are you likely to lose your earnest money deposit, but you'll also be in default where my broker, us as the bad guy, the broker, may come after the 3% commission that you've agreed to pay. Now you can try to be the quote unquote good guy and say like, I'll talk to the broker and maybe, they'll settle for just 1%. So that way you get something out of it. But I mean, it is a point of leverage to keep your clients from defaulting, because that's not a good thing when they do that. If they've agreed to a contract, they need to, uphold the contract and not default. The commission obligation shall apply to any purchase agreements executed during the term of this agreement. So even if it's just 2 days, so any purchase agreements written over these 2 days, the commission obligation will apply, or during an extension of this agreement, or the commission obligation will also apply to purchase agreements executed within 6 months after the expiration or other termination of this agreement if the property acquired was presented to buyer during the term of this agreement. So by having just a 2-day contract because that lead doesn't want to commit to you for 6 months, well, you are protected that, okay, anything you show them during these 2 days, if they then end up buying it within the next 6 months, they owe a commission because the property that they end up acquiring was presented to them during those 2 days. So that's where this protection period is what protects you if you do a short um, contract length. Now, it used to be that we had procuring cause. My current now I'm not the end all be all arbiter of this, but I no longer view procuring cause as something that can get in the middle of a transaction where, let's say, you show 123 Main Street to your client during this contract, and then a week later they have their friend write up an offer to purchase 123 Main Street. Now, this clearly lays out that the buyer owes you 3%, but procuring cause used to be that you could, try to get the commission that was being paid at closing. My current view, though, is that that's not likely to work because the actual commission from the transaction that is negotiated as part of the purchase agreement itself. It's no longer that, oh, there's a commission being offered in the MLS, and so you have procuring cause to get that commission that's presented on the MLS. Now, the actual commissions being paid from the seller side or what have you, that's being determined by the purchase agreement itself, and we don't have any claims to those terms or those details of that specific transaction. Um, so, so we couldn't use procuring cause to get a commission from the closing table. All it would be is that we'd be letting the client know, the buyer, that, hey, you still owe us 3% because you purchased 123 Main Street, when we showed it to you during this contract and we were acting as your exclusive agent. So they may end up using a different buyer's agent to write up the offer, and that purchase agreement would have a commission going to that buyer broker and not us. But it doesn't relieve the buyer of their obligation to this contract, and so the buyer may, is, in my view, still liable to pay us directly after the closing. But again, pursuing litigation in that realm is easier said than done, and maybe not the best practice. It's up to you. All right, so compensation credit. This is the crux that most buyers are going to be interested in. It states that buyer will receive a credit against any amount owed pursuant to paragraph 4. So any of these amounts that the buyer owes, they will get a credit against that amount for any compensation paid to broker by the seller or the seller's listing broker. So when you write up an offer and you incorporate as part of that purchase that the seller or the listing broker is paying 3% to us, then that 3% gets credited against the obligation of the buyer. And so then, they still pay the $495, but they're not obligated to pay an additional 3%. We're collecting it from the seller or seller's listing broker, and it then decreases their obligation here. But what is very important to note is that this sets the cap. What you have in here sets the most that you can get for compensation from a transaction in consideration. So any source that may not receive compensation that exceeds the amount agreed upon herein. So if you have less than 3% here, let's say you had 2.5% or 2%. If you then later write up a purchase agreement asking the listing broker to share 3% because they were, let's say, offering that, you can't accept that full 3%. You can only accept the 2% because that's what's here. Well, and I guess you could also apply it against their $495 obligation. But yeah, so that's why it's preferable. And when you're negotiating with your clients, your potential clients, you should tell them, hey, let's have I work for 3%. I'm going to put 3% here because that if I put less than that, a lot of sellers are still offering 3%, and I'm not able to accept their offer of 3% if we have a lower amount here. Now, if during negotiations the seller, is only willing to pay 2.5% commission, if we come to terms, yeah, I can always adjust this down, but I can't as easily adjust it upwards. So let's go with 3%. All right, disclosure of the broker's role. At the time of any initial contact, the designated agent shall inform all prospective sellers and their agents that the designated agent is acting on behalf of the buyer. So basically, it's the same when we put in a showing request. It'll often ask, how are we acting, transaction coordinator, what have you. We're a buyer broker. Designated agent and supervisory broker will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction. Buyer acknowledges and agrees that this confidential information being withheld shall not constitute a breach of any fiduciary duty. So basically, yes, we owe a fiduciary duty to our clients by being their agent. And so we have to tell them everything we know. But this is laying out an important exception to that, which is if we've had a agency relationship with somebody else and we've gotten confidential information as a part of that relationship, we don't, we can't share that confidential information with this client signing this contract. So yeah, this is meant to this contract, the theme, it's protecting us. If a client were to later try to sue us to say, hey, you didn't tell me, that other person that you used to have the listing, and that listing was, the sellers were willing to accept 100,000 less than the list price. You didn't tell me that. Well, yeah, if you got that information because you were the seller's agent at the time and then it was relisted with somebody else, you can't give that information to your buyer without breaching the fiduciary duty to that past client. And so this is just protecting us in situations like that. All right, conflict of interest when it comes to buyers. So you may have more than one client. You may be signing this contract with Jack, and Jack wants to see 123 Main Street. Well, Jack is acknowledging that you may show 123 Main Street to Jill as well, another client of yours. They acknowledge and agree you may show more than one buyer the same property and may prepare offers on the same property for more than one buyer. And then you shall preserve any confidential information disclosed by any buyer client and not disclose the existence of or terms of any other prepared offer on behalf of one buyer to another. So Jack wants to see 123 Main Street. Jill wants to see it. You're not able to tell Jack about Jill, and vice versa. And if you write an offer for one, you're not able to tell the other that the terms of the offer. So you have to keep the information confidential and separate. So that's another exception to the fiduciary duty owed to each of them, because it's in a way protecting the fiduciary duty owed to each of them. In the event you work for two competing, you shall be working equally for both of them. You shall not give better advice to Jack than Jill. And even though you don't have the full range of fiduciary duties, because you can't say like, okay, well, yeah, Jill is offering 10,000 above. So if you offer 11,000 above, your offer is going to be better. So in this situation, the competing buyer clients are giving up their rights to undivided loyalty and will be owed only limited duties of disclosure, obedience, and confidentiality. All right, conflict of interest when it comes to sellers. So if 123 Main Street is your listing, then this deals with that situation. So if a particular seller is represented by another designated agent, lowercase designated agent, within the broker, so that would mean any other Remax Platinum agent that has it listed, um, then the broker and supervisory broker shall automatically be deemed disclosed consensual dual agents. But you, as a capitalized designated agent, you can remain their buyer agent. So an Ann Arbor Remax Platinum agent has a listing, and you're working, from the Brighton office or Grand Blanc office, and you show it. Yeah, you can maintain that you are a buyer's agent only, but the broker and supervisory broker become consensual dual agents. But if 123 Main Street is your listing, so if a particular seller is represented by capitalized designated agent, which is you, then how should that be handled? The two options you have are you terminate the buyer contract just for 123 Main Street, and then you'll continue to be their buyer agent for any additional properties out there that you show them. And then what's interesting is any fees previously paid to broker by buyer pursuant to this agreement shall be returned to buyer at closing. So if you were to have anything up here for retainer or anything like that, or basically all of this compensation of the broker, if you check this box and you're showing 123 Main Street, which you are the listing agent as well, you don't get any of the compensation up here because you have terminated this agreement on that transaction. So yeah, you would be only working as the listing agent. You would not be their buyer's agent. You would not be a dual agent. And therefore then you're not collecting the $495 because we've given them no agency during that transaction in which you are acting solely as the listing agent. I typically, though, recommend instead that you check this box saying that you will act as a disclosed dual agent of both the buyer and the seller. So, and that's important to have this up front because you need to know what type of agency you're partaking in as soon as you step through the door at 123 Main Street. That is your listing. Are you stepping in there as just the listing agent, or are you stepping in there as a dual agent, having it built in to this contract and in the listing contract, because they have the same exact language in the listing contract. That is what then provides guidance as to how to properly stay compliant. And so what I recommend is whatever you choose between one or two, that you do it consistently across your listing contracts and buyer contracts. I recommend, though, this one, the second option, where you then act as a dual agent. We do not act as transaction coordinators, especially because you can't really be a transaction coordinator when you have already done agency. You can't revert back to transaction coordinating. You've broken that seal. All right, buyer disclosure. Buyer agrees to disclose to the designated agent relevant personal and financial information to assure you, the designated agent, that the buyer has the ability to complete any transaction which is subject to this agreement. Buyer hereby grants to you the authority to disclose such information as you deem necessary or appropriate in order to influence the decision of seller to accept an offer from the buyer. So the buyer lets you know that they have $1 million in the bank and they're writing an offer on a $400,000 house. If you were to tell the listing side, the seller, that the buyer has $1 million in the bank, the buyer could later try to say, hey, you shouldn't have done that. Well, again, the theme of this contract, it protects you, protects us. Buyer hereby grants you the authority to disclose such information as you deem necessary in order to influence the decision of a seller to accept an offer from a buyer. So, if they've told you, now, I don't personally recommend that you tell them that the buyer has $1 million in the bank if the offer is for 400,000, because it can undermine your leverage in negotiations. But whatever you decide, it's your decision. You get to choose what you deem necessary during that process, and this paragraph protects you in that regard. All right, so leasing or optioning. This agreement shall also apply to situations where the buyer wishes to lease or option property. In those situations, the terms used in this agreement shall automatically be changed as appropriate. So the term shall mean lease, rent, option, and then seller shall be lessor, landlord, what have you. What's important to note is that if you have a lease client, this contract isn't necessary. It's still a good idea to get clients under contract if you're helping them in order to protect yourself. But as far as the NAR settlement goes, the settlement that required having this contract in place before you go out showing properties, that only applied to purchase transactions and not leases. Um, and because in part, uh, here when you get into um, flat fee or how the compensation on the lease, typically it's half a month's rent, um, and so it can be a little tricky, I guess, to craft that using this form for your lease clients. But you definitely can do it and should do it, but it's not a requirement. And then the commission is going to be likely spelled out in the lease itself if you're getting paid from the landlord side of things. All right, cost of services or products obtained from outside sources. Broker will not obtain or order products or services from outside sources, so like inspections and such, without the prior consent of the buyer. The buyer agrees to pay for all costs for products or services so obtained regardless of whether or not the buyer purchases desired property. So if the buyer says, "Hey, um, I don't know anybody that does well and septic inspections," and you give them a recommendation, a couple different options, and like, okay, fantastic. Can you coordinate with Enviro Assist to have them do an inspection on the property? If they've told you to do that, then this contract makes it clear they're agreeing to pay for all costs associated with that inspection, even if they don't end up buying the property. So, yeah, broker will not. You're not going to order that well and septic inspection without the prior consent of the buyer. But if they give you consent or give you that direction, yeah, they are taking on responsibility for the costs incurred. Indemnification, again, protecting us. Good to have a contract for that. Buyer agrees to indemnify and hold harmless broker, designated agent, supervisor, broker on account of any and all costs or damages arising out of this agreement, provided no one at broker is at fault. Such obligation to include, but not be limited to, reasonable attorney fees and costs. So you're out there showing them a property and they fall down the stairs. They're agreeing to hold us harmless for that damage. Unless we push them down the stairs. If we are at fault, then okay, this does not protect us. But if we're not at fault, it can't simply be that they incurred costs or damages during this process, and therefore then they want us to be responsible. Well, not if we're not at fault. Non-discrimination. It is agreed by broker and buyer that the parties to this agreement, as required by law, discrimination because of religion, race, color, national origin, age, sex, disability, familial status, marital status, all the protected classes, sexual orientation, gender identity or expression. Um, so no discrimination allowed with respect to any of those protected classes. And then local ordinances may offer additional protection. Like I believe the Ann Arbor area has income source as a non-discrimination protected class as well. So you're not able to discriminate against Section 8 housing vouchers, that sort of thing. So, beyond what's in Elliott Larson statewide non-discrimination, you should be aware if there are local ordinances as well. Counterparts. agreement may be signed in any number of counterparts. So if you have 2 copies of this contract printed out because there's 2 buyers, and you mail one to one buyer and they sign it and send it back, and then you meet with another one and they sign the other one, and you can combine the 2 different signed copies of the same thing to have it be effect as one. Electronic communications are like legitimate, and they are binding if you do any sort of electronic signatures. Any electronic communication shall be deemed delivered at the time it is sent. So that's, again, protecting us. Condition of the property. Buyer is not relying on you to determine the suitability of any desired property for the buyer's purposes or regarding the environmental or other condition of the desired property. So this means that if they have buyer's remorse, it is not our fault. They are not relying on you to determine the suitability of any property for their purposes. Again, the theme of this contract: protect us in case somebody wants to sue later. So it's on them to do their due diligence to make their decision. And so if you're sitting down with a buyer and they're looking at this contract and like, wow, this is a lot of stuff that protects you. It's like, yeah, because I couldn't operate as a buyer's agent and take on the liability where if I help somebody buy a house, they say they want that house and I help them buy it. If they later have regrets and wish they hadn't bought it, I can't have it be that they can just sue me. So I need to have this language in here in order for me to operate as a professional. Otherwise, the risk would just be way too much. So that's why these protections are built in, because otherwise, it just would really hinder our ability to do our job. Limitation. Buyer and broker agree that any and all claims or lawsuits between the parties must be filed no more than 6 months after the date of the termination of this agreement, waiving any statute of limitations to the contrary. This agreement constitutes the entire agreement between the parties, so anything that was written up or said before gets rolled into and superseded by this agreement. This agreement may be canceled or revoked only by mutual consent of all parties in writing. And so then by signing, they acknowledge that they have read this agreement and received a completed copy of it. So that is it. It is much shorter than the listing contract and a little easier because the listing contract was all about creating a offer to purchase, basically. But this one is more just protecting our liability. So let me stop sharing. So are there any questions?
No, I'm good.
Okay.
All right.
Yeah.
Okay, thanks. See you
All
tomorrow.
right. Yep.
All right,
Bye.
bye.